Ready, start. Mr. Ketan Pal, learned counsel appearing on behalf of the appellant, submitted that a full and final settlement was arrived at between the parties, thereby indicating that a distinct understanding was arrived at between them. Full stop. No plea or assertion has been made by the respondent, nor any prima facie evidence has been adduced to establish that the appellant had made the execution of the discharge voucher a precondition to the payment of the claim, or offered the amount on a take it or leave it basis, close full stop. It was further submitted that there has been an inordinate delay on the part of the respondent in leveling allegations of coercion. Full stop. Such allegations came to be so labeled for the first time in the arbitration notice dated 2/3/2020, that is, almost 14 months after the payment of the subject claim and 5 months after the payment of the second claim. Full stop. The council submitted that the claim amount as per the assessment of the loss by the surveyor was known to the respondent since 24/12/2018, thereby indicating that the allegations of coercion were an afterthought. Full stop. He submitted that even when examined through the eye of the needle close test, the claim could be said to be deadwood, and the arbitration application ought to have been rejected by the High Court on this count alone. Full stop. The council also placed reliance on the decision of this court in New India Assurance Company Limited versus Genus Power Infrastructure Limited, reported in (2015) 2 SCC 424, to submit that arbitration ought to be refused in case of inordinate delay in raising the dispute or leveling allegations of coercion by the party seeking the referral of disputes to arbitration. Full stop. One another submission made by the council was that the pleadings of the respondent lack the basic material particulars about any alleged coercion and the poor financial condition of the respondents. Full stop. It was further submitted that even in the arbitration notice, all that the respondents have stated is that had they not signed the discharge voucher in respect of the first claim, their second claim also would have been affected. Full stop. The council submitted that the letter dated 25/10/2019 addressed by the respondent cannot be said to be a protest letter, as the letter only asked for a copy of the surveyor's report to be provided, and no allegation of any coercion or any demand for any amount was even raised in the said letter. Full stop. The council finally submitted that a discharge voucher for effecting the full and final settlement in relation to the second claim was also signed by the respondent on 39/2019, which was accepted, and no dispute has been raised in the last 5 years, which indicates that the appellant acted in a bona fide manner as per the prescribed norms. Full stop. Ms. Savita Singh, learned counsel appearing on behalf of the respondent, at the outset submitted that her client had to succumb before the surveyor on account of acute economic distress and also on account of pendency of huge amount of claim with the appellant, that is, around rupees 8 crore cumulatively arising out of the two claims. Full stop. The respondent was also under pressure from other financial institutions from whom loan had been availed. Full stop. The council further submitted that the circumstances were such that her client had to issue the discharge voucher, otherwise payment towards the admitted amount would not have been released and her client would have been put in immense difficulties. Full stop. She submitted that mere signing of the discharge voucher by her client would not imply that there was consensus in arriving at the full and final settlement. Full stop.